Okay, hi, my name is Swathi Sekhar, and I'm here on behalf of the Immigration Legal Committee and also the Law Union of Ontario. Something that we're all feeling as legal professionals and as community workers is just that there's been so many changes in the last little while, and it's really, really hard to get a grasp of it. And a lot of the changes are highly technical, very procedural, they're released incrementally. And so I kind of just want to stop and take a step back and try to get a sense of the bigger picture and what the cumulative impact is of all these changes. And what we really see overall is this active tightening of Canada's immigration and refugee determination system and sort of less pathways to actually gaining permanent residence, a greater emphasis on enforcement, and sort of this divide between what's a desirable and an undesirable immigrant or refugee, which really just creates a lot more divisions in our city and our country. So first, I just want to talk about the Balanced Refugee Reform Act. So this was implemented in June 2010, but some provisions came into force just this past December. So the BRA, as we call it, is really aimed at kind of shortening timelines and increasing efficiency, particularly in the refugee determination system, which on its surface is actually a really good thing, because as Gina was mentioning, we have a huge refugee backlog, and claimants are waiting up to 3 years to get their claim heard. However, the way that it's been implemented really comes at the cost of procedural fairness for a lot of refugees. So as Gina alluded to, the entire refugee determination process now is going to be completed within 60 days. So this means filing a claim, finding adequate counsel, collecting all your evidence, which is often from overseas, doing affidavits, preparing for and attending the oral hearing, and having a decision being made. This can be compared with the old system where claimants were given on average a year to prepare for their hearing and 60 days notice before the oral hearing alone. And even this was oftentimes inadequate to effectively prepare a case because you are collecting a lot of evidence from overseas. It's sometimes really difficult to find adequate counsel and funding for it as well, and to address the real issues of displacement and trauma that are experienced by a lot of refugees. So next I'm just going to talk about the PCISA, Protecting Canada's Immigration System Act. So this was just passed in this past July, and some of it, again, was passed in December. So again, a focus on increased efficiency, greater enforcement, creates new classes of claimants, so something that Gina mentioned around the designated countries of origin. So you can see on page 15 in the appendices of this report is kind of a list of the current list of DCOs. It also has a timeline, which I was just speaking about, in terms of the refugee determination process that you can take a look at. And a list of the new federal skilled trade workers program, all the occupations, which I think was alluded to this morning, or referred to this morning. So right, creating a class of refugees that are from designated countries of origin. Another class of refugees that are created are designated foreign nationals, so people who arrive in groups of 2 or more that the minister deems to be a way of coming by means of human smuggling. And this provision actually applies retroactively to March 2009. So the ministry actually said explicitly that they did the retroactive implementation so that they could include the Tamil migrants who came on the MV Sansi in 2010, 492 Tamil refugees that came. So even if they have permanent residence, this can be revoked if it's deemed that they're a designated foreign national. Finally, I'm just going to talk about C-43, which is a bill that hasn't been passed yet, called the Faster Removal of Foreign Criminals Act. So this act is aimed at protecting the safety and security of Canadians. And what's really scary about it is it authorizes the revocation of permanent resident status if you're convicted of a crime and sentenced to 6 months or more. So what this really means in real terms is that somebody who's been in Canada for 25 years as permanent resident and commits a relatively minor crime that carries a sentence of 6 months can then be deported back to a country that they've never known.